Okay, good afternoon, everyone, and welcome to our Postdoctoral Affairs Seminar Series. I'm Madhumita Joshi. I'm Director of Postdoctoral Success at UTSA. So our today's Postdoctoral Affairs Series topic is immigration education and status maintenance. And all you postdocs and some graduate students, if you are here, especially I assume 90% of you are here are international postdoc and graduate student, and we all know how important it is that immigration education and our status maintenance. Rather, I generally suggest my postdocs that this is one topic as important as our research, because I myself, being as a former international student and postdoc, I know how hard it is and how critical it is to go to step by step of our immigration education alongside our research. And it takes a lot of time based on your country of residence that to go if you are planning to go for green card. So rather it's like another thesis you are writing. So it's always good to have education well in advance so that we are prepared, especially sometimes even our every citation. Obviously, Mr. Malik will tell you that how to prepare for green card, but from my experience is every hour paper, how to collect them, how to see who are citing those. So all these documents are necessary, and those are very important to learn in advance so we can have time to prepare, because I have experienced some postdoc received, got an excellent job, but cannot go for the job, accept that job because of their immigration status. So this is the whole purpose of today's postdoctoral affair seminar topic, immigration education. And I welcome all of you, and thanks to our Director of International Student Success, Mr. Ashley Wallace, and our immigration attorney, Mr. Malik, who are joining us today to educate you all. And again, I want to mention this is purely for education purpose. And after that, if you need help, you can directly talk to Mr. Ashley Wallace and Mr. Malik for further guidance. Yeah, so welcome, and you can take from here. And thank you, Mr. Wallace and Mr. Malik, to join us here and educate us. Thank you.
Thank you, Dr. Joshi. Pleasure to be here today to speak to you all. For all of you that do not know me, my name is Ashley Wallace. I'm the Director of International Student and Scholar Services here at UTSA. Been with the university 11 and a half years. All 11 and a half years have been in the international office. Like Dr. Joshi, also a former international student, came to the United States on an F1 student visa and have transitioned to recently becoming a U.S. citizen. So been through the entire cycle of an international student, so I can understand and relate to most of your experiences. So with that being said, I'm going to cover today primarily J1. So most postdocs here are in the J1 visa, so the research scholar category. I'm going to talk about maintaining that status, also briefly touch on OPT for anyone that might be F1 or already on their OPT. And then I'll do a brief section on H-1B for the university, for UTSA academic H-1B. And then I know Shahid's going to go into more detail with permanent residency, national interest waivers, things like that. So without further ado, let me see if this actually lets me move. Okay, so important things to remember regarding visa status. While you're in the United States, either on J1, F1, you need to know and understand the following important information that I'm going to share with you all today. And this is to properly maintain your immigration status. As Shahid will probably mention later on as well, it's really important to take this seriously, because when you're filing for an immigration benefit, especially if it's a change of status, the part of the process is that you have to show that you've been properly maintaining your current status to get approved for the new status. So for example, anyone that's on a J1 or an F1, so this applies to both. Something as simple as your local US address. This needs to be reported to my office within 10 days of the change. then we actually then will take this information, report it to the U.S. Department of Homeland Security in the SEVIS database. That SEVIS database, for anyone that's not familiar with it, it stands for the Student Exchange Visitor Information System. So basically it houses all immigration information related to the F1 status and J1 statuses. And for UTSA, we have roughly about 1,000 students in F1, another 350 or so on F1 OPT, and about 50 or so in the J1 status. So roughly about 1,500 students and scholars that we report to SEVIS on. Also really important to maintain your passport. So when you are entering the United States, it's preferred to have your passport valid for at least 6 months in advance. If your passport is going to expire while you're here in the United States, perfectly fine. Really, all you would need to do is contact your embassy. So contact your country's embassy in the United States. Typically, Houston will have a consulate. Most embassies, of course, in DC. There might be a few others throughout the United States as well, in California, for example. But you'll need to start that process with your embassy, and each embassy is slightly different. So I mean, one process does not fit every individual. So basically, I would start this process at least a year, 6 months in advance to get your documents processed in a timely manner. So that way, if you do travel out of the United States, it'll be easier for you to return with the updated passport and your J1 or F1 visa stamp. Once you have that passport updated, again, really important to share that document with us because we're going to update immigration records with this information. So again, we're going to put it in our portal and we will then share it with Homeland Security, updating the information in their system. And if you have any passport issues, for example, if you lose it, it gets stolen, report that to us right away because there is a process that we need to follow. It'll involve like filing a local police report with the San Antonio Police Department and also contacting your embassy to help you with the replacement process. Another really important document is the I-94 form. The I-94 essentially is your arrival departure record, which is issued each time you enter the United States. For F1 and J1, there's no expiration date per se. It is always going to have D/S for duration of status, which basically means that you don't have an actual end date that you're allowed to stay in the country. The important document is your I-20 form if you're an F1, or the DS 2019 if you're on a J1 program. And basically, as long as either one of those two documents is valid, then you are allowed to remain in the United States to complete your program. Now, for any reason, if you do have an actual end date listed on your I-94 form and you did enter either as a J1 or an F1, let us know immediately because we can help you get that corrected with the San Antonio airport by visiting the Deferred Inspections Office. Also, this is going to be a really important document later on as well when you're applying for those change statuses or potentially going for an adjustment status to green card. Again, so the I-94 is really, really, really important. I would recommend every time you enter the United States, download this document as soon as you enter the United States. So that way you can verify that the information is correct. If the information is not correct, then let me know, let my office know as soon as you can, and then we can help you get the information corrected in the system. This is basically what that document looks like for any of you that have recently downloaded it. It's going to have your admission number or your I-94 number. This number changes each time you arrive in the United States. It will also have your admit date or your admit until date. And basically, this one has a date because this individual entered on a tourist visa, essentially. So the B1 you'll see down here at the bottom. So these types of categories do have actual expiration dates. But again, the J1 and the F1, instead of having this date, should have the duration of status, the D/S. And it will also have your name, date of birth, passport number, and country of issuance. Again, fairly simple. And again, this changes each time you enter the United States. For our J1s, really important question that I get asked a lot is, how do I apply for the 2-year home residency waiver? And basically, it's a process that the individual or the J-1 visa holder initiates with their embassy if they're applying for the no objection option. And I'm going to go into a little bit more detail on that as well. This 2-year home residency designation basically has a few consequences. So if you are subject to this, it means that you're not able to change your status while you're inside the United States. That means you cannot change your visa status to any other type of visa. That's including like an F1, B1, and definitely not an H1B or green card. If you are subject to that, there's 2 ways to satisfy the 2-year requirement. The first one is to actually satisfy it by departing the United States and remaining 2 years in your home country. Then you have completely satisfied the 2-year requirement. Then you would be eligible to apply for an H-1B or directly go to a green card if you're eligible. The other way is to apply for a waiver, and this is something that you would do inside the United States through the Department of State and your home country's government or your home country's consulate in the United States. The most common waiver category is the no objection statement, which basically is you contacting your home country's consulate in the United States and checking with them to see if they have if they have any objections to you remaining in the United States. And if they say no, you'll get an approval letter from them, and you'll go through a process with Department of State and USCIS to get an actual approval notice. Once you have that approval notice for the waiver, then you are eligible to apply for change of status or proceed with green card inside the United States. There's another category here with the advisory opinion. Sometimes you may be subject and you may disagree with the designation that you receive from the US Embassy. So in this case, you may request an advisory opinion by submitting a request to the US Department of State, provide a letter explaining why you think you should not be subject to this, and they will review typically in about 4 to 6 weeks. And if the embassy did incorrectly label you as subject, then it could be reversed. And this way you would then be no longer subject to the 2-year home residency requirement. There's a few other categories as well, but most of these are very rare that we really don't see many people proceed with. So here's a little bit more about the no objection statement. And it's basically your embassy is going to say that they have no reason for you to return home. And if that's the case, then they're going to approve the no objection. And then you'll just proceed with the rest of the application through the State Department Waiver Review Division. We're not able to really help you with this application since it is a kind of a conflict of interest with the J-1 program. So this is something that you would have to directly do on your own with the your home government and the U.S. Department of State. And this is a little bit more about the process. So once you have the no objection statement from your consulate or embassy, this will be shared with USCIS. Then USCIS will make the final determination on your waiver request. So if they decide to approve the waiver request, they're actually going to mail you an approval notice that's going to be on official paper from USCIS, which is the part of Homeland Security. With this document, then you are able to proceed again with that change of status to H-1B, or go directly to a green card if you have if you're eligible for that as well. I think here it says current processing for the no objection is between 12 and 16 weeks. We're kind of seeing a little bit less, roughly about, I'm seeing 8 to 12 weeks kind of. But again, these processing times are subject to change. Federal government really don't give you much notice if processing times change, but essentially they can be anywhere from 2 to 4 months. Little bit about program duration. So anyone here who's at UTSA with a research scholar or professor category in the J-1, you're allowed to be up here in the United States for up to 5 years. Most times, postdocs will come for 1, maybe 2 years at a time, and then work on an extension with their hosting department. If that's your case, just let me know. I can help you with that extension process. Really important, though, to submit any extensions of your DS 2019 before the DS 2019 expires. After the fact, we cannot extend it because it's no longer considered timely filed with us. My recommendation, if you know you need an extension, work on it at least a month prior to that expiration date, because the form that I need and a few other departments in the university need has to go to your department chair, to the dean of the college for signatures, and depending on their availability, this could take sometimes a week or two to get the relevant signatures that you need. So again, plan ahead. The other category that's very common at UTSA is the J1 short-term scholar. Very much, it's similar to the research scholar in the fact that it's research oriented. It's going to be mostly maybe a PhD student or a graduate student in another country coming to the United States to conduct some short-term research that's necessary to complete a thesis or dissertation in their graduate program. The maximum stay here is 6 months. This could not be extended. So if you need more than 6 months, you would need to proceed with the research scholar option. The research scholar option, though, also has another consequence as far as returning as a J1 research scholar. So if you are here as a J1 research scholar now or professor, you depart the United States and want to return to the United States as a J1 research scholar, you have to wait 2 years. This is different from the 2-year home residency requirement. It's a 2-year or 24-month repeat participation clause, essentially. You would be able to, however, return as a J1 short-term scholar for 6 months at the most. There's another category. Typically, this is for undergraduate students. So undergraduates that are in programs outside the United States and are coming to the United States to maybe do a semester of research, help them with their undergraduate program, will come as a J1 student intern. The maximum stay here is 12 months, cannot be extended, and it does require a bit of additional paperwork as well that the hosting department would need to complete and share with my office. Then for anyone on the call that's F1, if you are a non-STEM F1 student, you would have 1 year of OPT or optional practical training after graduation. For anyone that's a STEM student, so that is anyone that's in an eligible science, technology, engineering, or mathematics major, would have an additional 2 years of optional practical training, so a total of 3 years. 2 separate applications though, so even though you might be a STEM student, does not necessarily mean that you're automatically granted 3 years. 90 days before the current or the first 1 year of OPT expires, you would apply for the STEM extension. And if approved, then you will be granted an additional 2 years of employment. You will receive a new employment authorization document or an EAD card from USCIS with the new extension dates of employment. Really important for STEM students is that when you're on STEM extension, there are 4 required reporting periods that you have to submit to your school that holds your I-20 document. So for anyone that's a UTSA student and you're working UTSA or elsewhere, you'd be making these every 6-month reports to our office. And they're pretty simple. The 6-month and the 18-month reports, all you really need to do is share with us a continuation of employment letter, so a letter from your employer showing that you're still working in the same position, and we need to verify your address. Once we have those, then we report these to Homeland Security. Your 12-month and your 24-month reports, slightly different. There is a training plan that the student and the employee or the employer will complete together. It's a 5-page document. But on page 5 of that training plan, you and your supervisor would complete an evaluation. So there's a 12-month self-evaluation you would submit to us. We report to Homeland Security. And then there's the final 24-month evaluation, which you and your supervisor will complete and turn into us as well. And then again, we will share this with Homeland Security on your behalf. Anyone that's here that's H-1B or interested in H-1B, the max duration of H-1B is 6 years, can be applied in increments of up to 3 years at a time. So you cannot apply for all 6 years at one time. It would require 2 separate applications if applying for 3 years at a time. Little information here about the employment authorization. So this is primarily for OPT students. So you will have an EAD card, again, issued by USCIS. And you're only permitted to work in the United States the dates listed on the card. So any employment before or after those dates would be considered unauthorized employment and is not permitted and could have an impact on your visa status. Could end up in your F1 status being terminated for unauthorized employment. Really important here, F1 students must have this EAD card to work off campus, unless it's during your program and you're doing what is called curricular practical training. This would be an internship required for your degree program, which we would internally approve if you're a UTSA student, giving you permission to work at that offsite location with that employer that you'll be using for your academic credits. Just a little bit about H-1B, and I'm almost done. So H-1B is considered a specialty occupation, which basically means that in order to qualify for H-1B, there must be a need that there's no American workers that are eligible for this position. You have specialized knowledge. You must have at least a bachelor's degree or higher. The job also must require a bachelor's degree or higher. UTSA departments, if they're going to sponsor an H-1B for you, must pay 100% of the prevailing wage. If you have questions about these things, you can always schedule an appointment with me, and I'm happy to go into more detail about prevailing wage and labor conditions applications. Great thing about UTSA is we are CAP exempt, which means that we can file H-1Bs at any time of the year, and there's no number that we have to fall within. Shahid will cover a little bit more about H-1B CAP subject employers, which is slightly different. There is a time period where those applications are accepted. But yes, so UTSA or any educational facility or nonprofit research entities can apply for H-1Bs basically throughout the year at any time that we need. The current fees for H-1B, $460 for the form I-129. This will be paid by the department. Employee cannot pay this. For initial H-1Bs, there's also a $500 fraud prevention fee. This is just for initial petitions, not for extensions. If there was a change in employer, it would also be applicable. And then the final fee, which is optional, is a premium processing fee, or the 907 2805. Very expensive, but does guarantee a decision within 15 days from USCIS. This is the only fee that can be paid by either the employee or the department. If it's paid by the employee, then the prevailing wage and actual salary, there must be at least this amount in difference as far as because if the individual pays it, this technically would be deducted from the salary requirement. And if it falls below the prevailing wage, now that's an issue. We cannot proceed. And again, a lot of information here. Happy to discuss this in more detail if you would like to schedule an appointment with me, or you have questions about any of these categories. H-1B status maintenance, it's really important that any changes in your employment, if that's pay, work location, hours worked, even like a job title change, anything that changes in your employment, really just report it to me or my office. So that way we can review the change, and then we can make a determination if it's considered a significant change, and then help with guidance on filing an amended petition. So sometimes, there can be a change, but it's not considered a significant change, which would not require UTSA to file an amended petition. But again, anything that changes, is the best way here to proceed is to just let me know, and then we can make that decision for you. So that way you're not going to get into any trouble for doing anything that you're not authorized to do. And for anyone that's applying for H-1B inside the country, so let's say you're currently on a F1 or a F1, I mean F1 or J1, and you get an H-1B change of status petition approved, your I-94 will also be attached to this I-797 approval notice. So you'll actually will then have an end date on your I-94. Like when I previously mentioned earlier that anyone on F1 or J1 technically don't have an expiration date. Well, this would change with the approval of an H-1B change of status petition. Typically, that end date would be the H-1B approval end date or 10 days after the approval date, giving you essentially a 10-day grace period to either leave the United States or switch status. And that's my presentation, and I'm going to pass it on to Shahid, and then we're available for questions as well at the end.
Actually, I believe you have some questions I proposed in the chat to ask you questions.
Okay.
We can get them later. We can get them now.
Yeah, let's do the questions at the end then.
Okay, very good. Thank you very much, Ashley. And let me load up my slides. I can see that share button. There it is. All right. Thank you guys very much. Thank you, Dr. Joshi. Thank you, Ashley, in the international office. And thank you all for being here today to watch our presentations. We hope it's very helpful. We hope it's informative and you get your questions answered. While I am presenting, I have slides, and I don't prefer to lecture. So if you have questions, please ask your questions. I'll be monitoring the chat. And when the appropriate subject area comes up or at the very end, I'm happy to take questions. Yeah, please don't be shy. So today we're going to be presenting and discussing immigration options, both non-immigrant, which are temporary, basically work permits, such as the J's, non-immigrant, H-1B, the O, TN, things like that, H-1B. And I'm also going to be discussing green card options. So first of all, a little introduction about myself. I've been working with UTSA since, or almost 10 years, a little more than 10 years now, since around 2014. We handle the green cards primarily for the UTSA scholars and researchers like yourself. And I'll discuss that in a second, as you'll see. I have an undergraduate degree in computer science. I did not like programming for the rest of my life, so I took the LSAT and escaped it, went to law school, and here I am. I'm board certified in immigration law. I'm on the 9-member panel for the state of Texas that writes and grades the exam for other attorneys to determine if they can be deemed board certified experts in immigration law. My law firm handles everything immigration and immigration only. We do immigration A to Z comprehensively. That means immigration, business immigration, employment immigration, research scholars, universities. And on the other end of the spectrum, other attorneys in my office will handle matters such as deportation defense, asylum, and everything in between, such as family-based immigration. For example, you're getting married and you need to file a green card for your spouse or for your brother, sisters, parents, things like that. And of course, naturalization as well. All right, let's move on. We offer free initial consultations to anybody associated with UTSA. Here is our email address and our phone number. Call us, email us, schedule an appointment. I'm happy to talk to you. And I'm going to reference this email again shortly, or at the end, I should say. Some of you are going to have questions, and you're going to be submitting the questions or for any items you need reviewed for certain purposes, which I'll get into in a second. There's the email address. It's info@perezmalik.com. Okay, today's scope of the presentation is to present non-immigrant visa and permanent residency options. Have to give a disclaimer, this is not legal advice to you. This is informational purposes only. Here's our table of contents. This is what we will be discussing, and I'm going to move pretty quickly, especially at the beginning, so we can get right into the green card and any questions you may have. Okay, so you've received your temporary visa, now what? So here I have some 4 quadrants here, and they kind of go in order. The temporary work visas are not forever. The OPT, which is a work permit of a student status after you graduate, H-1B, J, O-1A, etc., the whole alphabet soup, they're not forever. And you need to graduate, if you will, into green card. Green card means permanent residency to the USA. Permanent residency is one step short of US citizenship. And so after you get your green card, 5 years later, in some conditions 3, you can apply for US citizenship. And once you have US citizenship, you can apply for a US passport. And that kind of completes your immigration life cycle to the USA. There's a whole alphabet soup of visas. You don't really have to figure out which one is best for you. That's you may be able to do that, but you should certainly discuss it with an immigration attorney. And green card sponsorship, similarly, there are many different options, and this is very confusing. They don't make it easy on you. And there's some categories where you do not need a sponsor. And then finally, after green card comes US citizenship. Okay, so what is a green card? It's permanent residency, no more visas, no more scheduling appointments at the embassy to get a visa sticker, things like that. No more interviews. You can get a green card through family sponsorship or employment sponsorship. Excuse me. How long does it take to get a green card? So the document that determines how long it takes to get a green card is published by the US Department of State every month, and it's called the Visa Bulletin. And if you're in front of your computers, if you want to Google Visa Bulletin, it'll navigate you there. Every month, the wait time changes, and it depends what country you're born in and what category you are in. Okay, so here's a chart on the family sponsorship side from a couple of years ago. And you'll see at the top, there are some countries listed. That is your country of birth or your spouse's country of birth, whichever one you want to use, whichever one is faster. And on the left-hand side are different categories of degrees of relationship. This is a family sponsorship one. And similarly, I'm going to show you later that there's a similar one for employment. C means current. C means today there's a green card for you. And if there's a date there, the date indicates that if you got in line on that date, today there is a green card available for you. So it's a very long line on the family side. These are categories. None of these represent marriage to a US citizen. We'll get into that more later. Okay, so let's discuss right off the bat the employment-based green cards. And employment-based green cards are multiple steps, and there's different types of green cards, different types of options. There's something called EB1, there's something called EB2, there's something called EB3. And in today's presentation, I'm going to kind of discuss with you the different options that are kind of geared towards what you do, higher education, research, things like that. Okay, some acronyms that you're going to need to know for this purpose is number one, I-140. What is an I-140? I-140 is just the name of a form that initiates or is the first step of the green card process. And it's an application that's filed by your employer sponsor on your behalf. And if you're in one of the categories that does not require a business or entity to sponsor you, then you file the I-140. It's just the name of a form, but most importantly, and most of the time, when you file that I-140, the date you file it is when you are determined to have gotten in line for purposes of the visa bulletin chart that I just showed you. That becomes your priority date. Okay. Another acronym that is going to be used is PERM, P-E-R-M. PERM is a acronym, but it's the labor certification, which I'm going to explain in a second. And if a university is hiring you after choosing you as the best qualified teacher or professor, you can do what's called a special recruitment perm. And that the perm application is filed with the U.S. Department of Labor becomes your place in line or your priority date. Okay, so I'm going to move along here. This is just an overview of green cards. So going back to the non-immigrant visas, Ashley touched on a lot of this already, J1s and an INA 212E, the 2-year foreign residency requirement. There was a question on one of these, when's the appropriate time to apply, and whether you're going to be re-subject to it if you get the waiver and then get back on J. And I believe Ashley is already answering those. So I'm going to pass on that for now. And let's move along. So there are O1A and TN visas. The O1A visa is if you have something called extraordinary ability, and it's a non-immigrant temporary work visa. And as I'm about to explain, sometimes these are strategic if you are unable to get on H-1B because your employer is subject to the lottery cap and you did not make the lottery. And if you meet some requirements, you can get an O1A and bypass the H-1B altogether. There's also a TN visa. TN stands for Trade NAFTA. It's a NAFTA visa, which is the North American Free Trade Agreement, which has been retermed. And for all intents and purposes, the TN visa still exists in its same name. This is only available to citizens of Canada and Mexico. And it's a good, tremendous option. Again, if you can't get on H-1B, you can fall back on TN or even have the TN be your primary. And so you see some common strategies. We go J to H, J to O, and then the different categories of green cards, and we'll get into that in a second. So the O1A visa is for those who have extraordinary ability. Okay, and there's something called the EB1A on the green card side. That's the highest category. And the categories are in tiers on the green card side. The higher qualified you are, the more the USA wants you and the quicker you get your green card. And they designate that EB1, EB2, EB3. EB1 is the highest qualified, EB2 is the next, and EB3 is the third preference. And you will find that the green card preference categories have a mirroring non-immigrant visa category that kind of parallels with it. And for the extraordinary ability green card category, there is also an O1A extraordinary non-immigrant visa work permit category. And so typically this means you're going from F1 to OPT to O1A, or you're going J to O1A. And in order to be qualified or approved for an O1A status or visa, you have to prove 3 of the following. And I'm not going to read all these to you, but here they are. And you need a job offer to work somewhere, and you have to basically explain that you are amazing. And by amazing legally, that means extraordinary ability. I'm just reading some of the questions. Let me move along. H-1B visa eligibility. So Ashley mentioned what H-1B cap exempt means. So let me tell you what cap subject means. The H-1B is a type of visa. It's probably the most commonly used. And in order to get an H-1B, you need a job offer from an entity or business in the USA. The job offer must require at least a bachelor's degree, and you must have earned at least that bachelor's degree or equivalent. And every year, the US government awards only 85,000 H-1Bs each year. Okay, 20,000 of those 85,000 are reserved for those who have a master's degree from the USA. However, there's 200,000 or 300,000 applications, and so because there's more need than there is availability, immigration holds a lottery every year. The lottery is now held about in late March, and the results are out slowly, but over the month of April and beyond. If you win the lottery, great. Now an H-1B can be filed on your behalf. And if the H-1B is approved, great. Then you can begin working on it on October 1 of each year. Okay. If you don't make the lottery, then you can try again the following year. However, if you want to stay here in the US, you have to find a way to maintain your status, as Ashley discussed. Maintenance of status means you got to do what you're supposed to be doing on the particular visa. And it also means that if you're here, then you need some type of valid I-94 and valid status. So typically that means you may be remaining on J. If your F1 OPT time is ending or is expired, then it gets a little hectic. You may need to go back to school to bridge the gap. You can change to tourist status to buy some time. And there's some other strategies as well. However, it does get a little bit hectic. If your employer is not subject to the cap or cap exempt, then you can get on H-1B anytime. There's no lottery. That's the best of all the worlds. And those types of job offers are from nonprofit research entities like a university, but more than just universities as well. Okay. Once you do get on H-1B, there's a 6-year limit, and you basically need to get a green card before the 6 years is finished. The 6-year limit is removed when you get your, sorry, I keep going forward, when you get your I-140 approved. And so if you are born in India or China, there's a tremendously long wait time for a green card, even after your I-140 is filed and approved. However, the law provides that if your I-140 is approved, then you can continue extending your H-1B beyond the 6-year limit. And in order to get an H-1B, you need a job offer. It must require at least a bachelor's degree. The employer must agree to pay you a certain minimum wage called the prevailing wage, and it needs to be entered on Department of Labor's labor condition application, not to be confused with labor certification, which is a perm. Very confusing terminology. They don't make it easy. Okay, for TNs, if you're Canadian or Mexican and you're a scientist or research assistant or any of these, you can get on TN. One of the key differences between a TN and an H-1B is that a TN, you are limited to what you can do for your occupation. You cannot just be anything you want to be. You have to pigeonhole your occupation to one of the occupations on the TN list. On the H-1B, on the other hand, you can be anything you want to be, any job position, so long as the job offer requires at least a bachelor's degree. So here are some applicable positions on the TN. So there's research assistant, scientific technician or technologist or scientist, and the minimum requirements. Okay, moving along to back to green card. So EB stands for employment based. This is category 1, EB1, and this is the toughest category, the most desired category to the USA. And if you meet these requirements, it's one of the fastest ways to get a green card. So this is a category reserved. This is called the EB1A, extraordinary ability. And it's a classification for those who are at the very top. If you have an Olympic medal, Nobel Peace Prize, Japan's Kyoto Award, things like that, the USA wants you here and they will give you a green card quickly. You'll be at the front of the line. And if you don't have one of those major awards, you can still get eligibility into this category if you have 3 out of 10 factors, which I'm about to show you. And the procedure is you file an I-140. Once it's approved, then you file the green card. Meanwhile, until you can file the green card, you must continue to maintain your status. Filing the I-140 does nothing for your status. You could even file the I-140 if you have never been in the USA before. And that's just the point I'm trying to make is the I-140 does not do anything for you even after it's approved. It only permits you to get in line and to then file the green card. Once you file the green card, then you can stop maintaining your status However, that does not mean you can work without authorization. So I believe I have a question. Could I apply for an EB1 through my employer while I am on my H-1B as a postdoc? Or do I need to be a tenure track to apply through my employer? Okay, thank you for your question, Deepthi. So the answer is you can do both of those. So I understand your point though. So to clarify, the EB1 again is a parallel process to your H-1B. Your H-1B is what permits you to work and be employed now, today. The I-140 is what permits you to file a green card tomorrow. And so typically, yes, you're going to be an H-1B now, and then you need to file an I-140. Whether you file the EB1A I-140 or EB1B I-140, depends on many factors. You want to pick the path of least resistance. If you choose the tenure track category, that category is the EB1B, and it's the internationally recognized outstanding professor or researcher. That one, to me, is the path of lesser resistance most of the time. The EB1A category does not require a sponsor. No employer is required. You can file on your own. Consequently, the bar to entry, or the bar to entry into approval, I should say, is a little bit higher. The EB1B, which I'm about to get into, requires a job offer from a university or nonprofit research agency or any type of even for-profit research entity, and the burden to approval is a little bit less. So this is the EB1A continued. And these are the categories that you need. You need lesser prizes or awards, members of association. You have got work published highlighting your work. You've judged the work of others, and you can read the rest of these. So these should be evident from your CV, and then you'll have to prove it by letters of recommendation. If you've been the judge of the work of others, you'll need to show that you were invited. For example, if you're a peer reviewer, which everybody is, by the way, doesn't distinguish you that much. But if you have served on an editorial board of a journal, those things kind of distinguish you. Okay, moving along. This is the EB1B, outstanding professor or researcher. And if you have a job offer that's tenured or tenure track at a university and you're teaching, or you have a job offer as a researcher and you have 3 years of experience teaching, and you have a job offer and you can prove 2 of the 6 following items here, then you can do an EB1B I-140. This is probably one of the best categories if you can get the job offer. The cases that I have done for UTSA have a 100% approval rate for the past 10 years. I've got it down. I know what immigration wants. I can check very quickly if I believe you'll be qualified or not. So I have very high confidence in this category. There's the bar to entry is high because you need a job offer and you must be tenure track or a researcher. But once you're in, you've probably gotten in based on your achievements anyways. And so these are the minutia. And in this category, you'll need to get letters of recommendation from other experts in your field, and they attest to why you are amazing. And we draft that letter together. And typically, you'll want to highlight that you have researched and been selected for publication for something that you've done that's considered novel or first of its kind or pioneering, etc. Okay, back to maintenance of status. I'm not going to spend too much time on here. You need your visa, proof of lawful entry, your DS forms, I-90 forms, I-20s, proof you've been working where you're supposed to be working, which can come from W-2s. You got to file taxes. And the main thing here is save everything to the cloud so you know that you won't lose it. Okay, before I get into this category, let me take some time to answer some questions. Does the EB2 NIW require job offer after the I-140 is approved? So the EB2 national interest waiver, as I'm about to explain, what is the waiver? It's a waiver of the requirement of a perm, which I'm about to explain what this is right here. A traditional perm requires an employer to prove that there are no qualified, willing, and able U.S. workers to do the job that they want you to do. This is to protect the U.S. workforce, okay? Universities have a relaxed version of the perm, and it's called a special recruitment perm. And instead of the university having to prove that there are no US workers to do the job, they only need to prove that after a recruitment that you were found to be the best qualified applicant, which is very subjective. And that's what makes this category very valuable if you have a job offer from a university. It does not require you to be tenure track. It only requires there to be a teaching element. So the application, one of the best things is it doesn't have to be filed. The deadline to file is 18 months after the date of selection. That means the date you have accepted your job offer. And that sounds like a really long time, but it really isn't. Why? Because Department of Labor is really, really slow. Our government, especially immigration, is really, really slow. So into the 18 months is what's called a prevailing wage request. They're taking about 9 months today. So once you decide to contact me, the first things we do to get the case going is filing the prevailing wage request. And if you've already been selected in the past, well, your clock is already ticking. So you don't want to delay at all. There's a 9-month delay just to get the prevailing wage request. And then after Department of Labor issues the determination, then only then can the application be filed no sooner than about 45 days later. After the perm application is filed, they are then taking another 15, 16 months for certification today. The 15, 16 months is not part of the 18-month deadline, but that's how long it takes after the submission. After it's approved, then you can file the I-140. Okay, so going back to the question, the national interest waiver. So to understand national interest waiver, the waiver in the word national interest waiver is a waiver of this requirement, of the requirement for your sponsor to file a perm. Okay, so for example, to conceptualize this, you're trying to prove, hey, immigration, or hey, US government, don't require me to find a sponsor to file my perm, because what I do is in the national interest of our government, and therefore I should not have to get a employer to prove that they cannot find any US workers. And then you have to find a way to convince immigration, which I'm about to get into. So to answer the question, the NIW does not require a job offer or a sponsor at the time of filing the I-140, but that only means you don't need a business to sponsor you, but you're still making the representation that you will work in that field. So if you get an I-140 approved and then file a green card and never work in a day in your life after that, and then file for citizenship and disclose all that, you could have problems at the time of citizenship. So you will be making the statement in your national interest waiver application, what you intend to do, what your role is, and to get the NIW approved, and you are expected to work. But there is no formal submission to immigration that you have a job offer or a sponsor. You could even be self-employed. That's fine too. Okay, so here is the slides on the national interest waiver. Let me check the questions real quick. Okay, I was in the IT sector and had a B1, L1B, and H1B visas. Then I made a career change and started my PhD in a J1 visa. Now my employer is applying for H1B. I think I used 3 years of my H1B. So this time I will only get 3 more years before my I-140 is approved, or will it be 6 years of H1B again because it's nonprofit H1B this time? So your H time is your H time is your H time. It doesn't matter if it's on a cap subject employer or a cap exempt employer. However, if you were on H1B and then you left the USA for a year and then got back on H1B, then it's your choice if you want to start a new clock or continue with the old clock. If you were in the IT sector, you probably got in on the lottery, but if you start all over again and you want a fresh 6 years, you can't have it both ways. So you will have to re-enter the lottery only after being out of the US for a year if you want to try to get the 6 years back. Okay. Will I get my, I will get only 3 more years before my I-140 is approved. So I believe what you're asking here is, once my I-140 is approved, do I get 3 more years? And the answer is yes. So your goal is to get your I-140 approved, because then there's no such thing as a 6-year limit anymore. You can be on H-1B indefinitely until your turn is called to file a green card based on your I-140 priority date. I am not subject to 212E in my J1 visa and my initial DS 2019, but I had a new DS 2019 for my AT where nothing is checked on the new. So if nothing is checked on the DS 2019 form, you don't know if you need the waiver or not. The next thing I would do is check your visa and see what it says. And then the next thing I would do is contact your DS 2019 officer that filed that for you, ask them. And finally, you can submit a inquiry to Department of State, an advisory opinion, and they can determine it as well. There's other tools to determine it that are probably a little bit more complex than I want to get into right now, that are based on the law, but that's how you can determine it. Okay, going along. If I've missed any questions, I don't believe I have. There's a question about the H-1B at the beginning, actually. I wanted to ask if H-1B visa holders sponsored by UTSA can create an LLC company. So I'm going to rephrase this question a little bit, and I'm going to open it up not just to sponsored by UTSA. I'm going to just say, if you are on H-1B, can you create an LLC company? Okay. And the reason I'm doing it like this is because if there are contractual requirements between your employer and you, for example, you have a contract with your employer and it says you cannot work anywhere else, then my answer changes, obviously, but we're not talking about business law or employment law, we're talking about immigration law. So in that regard, the rule is, yes, you can start another company. You can have as many companies as you want. You can own as many companies as you want. However, the key thing here is, and this sounds ridiculous, but it's the way it is, you cannot work for that other company. Okay, you can earn the profits, you can earn distributions from a business that you own that you do not have work authorization for. That's okay, but you cannot work for that business. Once you work for your own business, even, you are working without authorization, unless, of course, you have authorization to work there. Okay, so that would mean you need a second H-1B followed by your own business, which is very complicated. Or you can hire a manager to run your business for you such that you don't do any of the work, you only earn the profits. That's okay. Very fine line, very good question. And if you don't follow the rules, you will have severe consequences for working without authorization. Okay, I believe I've answered other questions, or Ashley has. If I missed a question, please retype it and I'll get back to it. Okay, so national interest waiver. The national interest waiver, as I just explained, is a waiver of the requirement that an employer prove that there are no qualified, willing, and able U.S. workers. The national interest waiver category is EB2. EB2 means second preference categories, which means it's not EB1, obviously. If you are born in India, the EB2 category, once you get in line, is still 10 years away or so. It's still a very long wait time. However, it permits you to get an H-1B beyond the 6-year limit. So sometimes you just got to do it, and then later you want to try to get into EB1 if possible. Okay, so the national interest waiver, you must have a proposed endeavor. Endeavor is a legal term of art. A lot of people confuse it with job or occupation, but endeavor is a bigger thing than your job or occupation. You have to show that it has something called substantial merit and national importance. You have to demonstrate you are well positioned to advance this proposed endeavor, and it would be beneficial to the U.S. to waive the job offer and the perm requirements. Okay. I'd like to throw in, usually the national interest waiver is sometimes a Hail Mary attempt. It is the path of most resistance because it does not require a job offer. If you can get a job offer typically your path of lesser resistance will be to go through another category. Sometimes you can't do that, but sometimes you just can't find an employer and you have to go this route. Moving along, some more requirements. So the Dunasar analysis is what we call it. Dunasar is the name of a case. This defines what is national interest. For example, these are some examples here. And you have to align these, or I have to align these with what's going on politically at the time of submission of your application. For example, right now, the hot thing is artificial intelligence, AI. And from the Biden administration, they have goals, and we refer to the goals for the tech industry at least. But at any time, there's a bunch of different goals that presidents put out, and we match the goals with your endeavors. So for example, these are the broad ones: U.S. economy, improvement of wages, infrastructure improvements. Common one in that regards are bridges. I think in the early 2000s, there was a bridge that collapsed in Minnesota, and then an engineer created some technology that gave some X-ray vision or something like that to determine the structural integrity of all the bridges around the USA with minimal invasiveness and rapid response. That was an easy case for whoever did that case. And then you can read all the other examples here. So what I've already mentioned before, this is a self-sponsoring. The requirement to prove that there were no US workers to do the job is waived. That's the waiver. Substantial intrinsic merit, and what is national interest, and you must have at least a master's degree or equivalent. This is what national interest means. These are some examples, and you need the last item there to prove it and some more. Okay, so oftentimes I get questions at the end of these presentations, and somebody will ask me, well, what do you think my chances are? What do you think my chances are? And then we schedule a consultation and we discuss your achievements. So what I've done here to get, if you have a question like that, what I've done here on the next slide is, if you want to get a head start on that conversation, this is what I will need from you before our consultation. And you can email this to that email right there, info@betasmalik.com. And I'll need your CV, and I'll need a personal endeavor statement. And eventually, after refinement, your personal endeavor statement is what gets submitted to immigration with your NIW application. And this is basically you telling me, internally only, not to the government, what you do, why you think you are qualified, what you have done, and what you're going to do to continue doing it. And I'll leave this slide up here for a second for you guys to screen capture or print or copy paste or whatever you want to do. And I believe we'll make the slides available too. And if not, you can just send an email and we can send you this. All right, moving along. How long does it take to get a green card in the employment-based categories? So you'll see a bunch of C's on this one, whereas the previous one that I showed you on the family side did not have so many C's. So C's are good. C means current. This is from November 2022. You'll see EB1 is current everywhere. That means that particular category numbers are set aside for those who are most qualified. You'll see in EB2, some countries of birth are current. India and China are not. And EB3 is very similar. EB3 means a perm case that requires a bachelor's degree or 2 years of experience as minimal entry. And second preference category is a master's degree at least for minimal entry. So the national interest waiver case is going to be an EB2 category. And the EB1 is the EB1A, extraordinary ability. There's also going to be EB1B, the category for outstanding professors and researchers that do have a job offer. Okay, there's also one called EB1C, and EB1C is the category if you are an international manager transfer, which is kind of beyond the scope of today's presentation. Okay, depending on the type of visa application, what is the cost range for obtaining a green card with the assistance of an attorney? So the answer is it really depends. And it's a question and answer, it's a dialogue to see where you're at. The answer is it widely depends. And I'm happy to, evaluate your CV and see what categories are available to you. Just call my office, schedule an appointment. The first consultation is free and we can discuss all that. If you are sponsored by a university, and in some cases, like for example, the H-1B and the PERM, you are prohibited from paying, legally speaking. The sponsor, the business, or the university is legally prohibited from letting you pay, and the attorney is legally prohibited from accepting payment from you. And that just means that the entity or the sponsor must pay the fees, only for some of the categories, but not all of them. But it's very complicated. They don't make it easy. There's different categories have different requirements. Okay. Going back to maintenance of status, at the time you are filing your green card and every extension and every visa, immigration wants to know that you have maintained your status. Maintaining your status again means that you're doing what you're supposed to be doing and not doing anything you're not supposed to be doing. And ignorance of the law is no excuse for not following the law. So the consequences are very harsh. If you don't know what you're supposed to be doing, ask. It's not a stupid question. On H-1B, what are you supposed to be doing? You're supposed to be doing what your application said you're supposed to be doing. The application will identify the employer. It'll identify your salary. It'll identify your hours, full-time, part-time. It'll identify where you're working, what your job duties are, what your job title is, things like that. On the H-1B, Ashley mentioned a $500 fee that has to get paid. That fee is called the anti-fraud fee, and it funds a section of immigration where the officers can come to your place of employment and check and see what you're doing. And oftentimes they'll ask you, hey, give me your business card. In some ways, people get in trouble is the business card has a completely different job title than what was represented to immigration. So ask questions and understand your situation, understand the law. Okay, question is, can I apply for F1 OPT while my I-485 is pending? Does the 90-day rule still apply for filing the I-485 if I am currently on F1? Okay, so a couple of things that I have not introduced here. The 90-day rule, I'll take this time to introduce it. So one question that I often get is, why should I pick a H-1B over a TN? And the main reason is if you're qualified for both a TN and an H-1B, yes, the H-1B is more expensive. Yes, there's more hurdles. It's more regulated. It's more difficult to get. You have to get it approved by USCIS. Then you can get it approved by the embassy in order to get a visa. Whereas the TN, you can go straight to the embassy and bypass USCIS. However, the H-1B is sometimes more valuable than the TN because the H-1B permits you to have something known as dual intent. Okay, all of you, I believe, in this segment are here on a non-immigrant visa that is not an H-1B or have been before. For example, the F1 or the J1 or the B2 or any number of them that are not H1. All of those visas, you may already know, require you to have something called non-immigrant intent. That means that you have the intention to go back to your home country after your stay here in the USA is finished. Okay. And if you violate that intent, then you can be deemed as having committed a misrepresentation, which is essentially fraud, which will result in a denial of everything in your future related to immigration. However, you may also have heard that people come into the US and, for example, a student, and they fall in love with a fellow student and get married and file a green card. And they get approved with no problems. And the difference in having applied for a green card after having a non-immigrant intent visa is that you are permitted to change your mind, but there's a fine line between having the preconceived fraudulent intent at the time of applying for your visa and at the time of applying for entry into the USA at the airport, for example, and then changing your mind, that's okay. If you change your mind, that's okay. That's not fraud. If you have the preconceived intent to get a green card at the time you were getting the visa or crossing the border, that's bad. That's fraud. So the question that's being proposed mentions a 90-day rule. And so the 90-day rule is basically immigration's guidance, and it's a loose guidance. And it basically says if you changed your mind or if you filed something after 90 days of entry, it's probably okay that and it is acceptable that you probably changed your mind. Okay. Contrast that with entering the USA yesterday on F1 and then today getting married and filing a green card, just 1 day overlap or 1 month overlap or 2 months overlap. So you could possibly open yourself up to having red flags if you file something too quickly before the 90 days. Okay. So to answer this question, can I apply for F1 OPT? Can you apply for a work permit? In other words, while my green card is still pending? Okay, does the 90-day rule still apply for filing the I-485 if I'm currently on F1? Okay, so there is many answers to these questions from many different attorneys, and some will take the most conservative approach, which is do nothing, file your EAD from the pending 485, and some will say it's fine. And so it's kind of dependent on how much of a risk you want to take. But to get into the nuts and bolts of it, technically you're not applying for F1 OPT. You are applying for OPT. You are applying for OPT based on your F1 status and some other things. Okay. Changing status to F1 or applying for an F1 visa certainly requires the non-immigrant intent. Okay, but you're not messing with your status. You're not doing anything to mess with your status. If your question was, can I extend my F1 status? My answer is going to be totally different. But in this case, you're applying just for an I-765, which is a work permit, and your two processes are parallel. So in fact, I have a client that's done this before, kind of out of desperation to continue employment, and it was approved just fine. But if there is a different political administration intact tomorrow, for example, the answer might be different in a year from now. So it kind of depends on a lot of factors and how things are going on the government side. The I-485 is a green card application. It does give you immigrant intent. So at that moment, I would not apply for any of the non-immigrant intent visas. For example, don't apply to extend your F1. You don't really, when you're applying to extend the F1, for example, you're making the intention at that moment that you will leave the USA because you don't have the intent to be here, which is a complete contrast with you wanting to be a permanent resident here. Okay, so that's a really long answer. I hope that was helpful. Okay, so let's move along to the non-employment based green card options. And so here I am presenting, but not getting into deep detail, immediate relative petition by a US citizen. Immediate relative does not mean what you think it means in your everyday usage of this word. And this is because nothing makes sense in immigration and nothing is easy. But immediate relative means a US citizen spouse, but not a green card spouse. It means children 21 years of age or younger of a US citizen. And it also means parents of US citizens that are age 21 and older. In that situation, that's the best situation to be in, even better than the employment-based categories. In those categories, you do not need to prove maintenance of status. If you worked with that authorization, no problem, you'll still get a green card. But if you lie about working with that authorization, now it's fraud, so be careful with that. You do have to show that you entered the country lawfully with your own visa, and that you don't have any other blemishes on your record. Okay. If you're not an immediate relative, then you fall into the preference petition categories. Okay. This is, for example, a green card spouse filing for a spouse, or a US citizen sibling filing for their brother or sister. In these categories, there's a wait time more than 5, sometimes 10 to 15 years. And just because you filed that petition called an I-130 does not mean you have lawful status. So you still have to maintain your H-1B or whatever status. Okay. Application for a waiver in immigration court. This is if you're in deportation proceeding, hopefully none of y'all. Certain victims of crime, if you've been, for example, you got robbed at gunpoint and you helped the police catch the bad guy, you can get a green card that way. Starts with a U visa, which will give you a work permit eventually as well. So little opportunities like that are awful, right? But they could open the door for a green card or other immigration benefit. Victims of domestic violence. This is called VAWA, Violence Against Women's Act, and it's not limited to just women. Men can get it too. If you're in a relationship, if you're married to a U.S. citizen or a green card holder, and they never filed your green card and they abused you physically or emotionally, and you can prove it, you can get a green card this way. There's also other employment-based green card options, as I mentioned earlier, that I'm not discussing here. One of them is an investor visa called the E2. There's a trader visa, E1, if you want to open your own business. That's a mechanism to do it with. It depends on your country of citizenship and whether the USA has a treaty with that country. Okay, so moving along. US citizenship. And so this is my last slide. So please keep them questions coming if you have any. Requirements for US citizenship. You need to have a green card first. You have to speak English. You must have paid all your taxes. You must have good moral character, which means you don't have any arrests in the past 5 years or more. You file your taxes, you pay child support, things like that. You have to be physically present in the US for half of the past 5 years. And there's another physical presence requirement as well. If you are married to a US citizen, whether or not they filed your green card, then you can file citizenship 3 years from that moment instead of the 5 years. Okay. Thank you guys very much for attending this presentation. Thank you, Ashley and Dr. Joshi. Here is our contact information again, phone number, email. If you have any questions, please reach out. If you have any questions right now and you want to put them in the chat, I'm happy to entertain them.
Thank you so much, Mr. Malik and Mr. Wallace. And any of you, I know there's a lot of questions. Maybe you can just ask directly. That might save your time if you want to. I know, Mr. Wang, I do see your raise your hand, but I'm not sure. Is it you want to ask any question? Okay, if you have any question, you can just ask or type here in chat, or also as they both of them said that you can directly communicate with them. And again, each case is so different, so it will be better to directly communicate with Mr. Ashley and Mr. Malik with your needs.
Okay, we have a question. Is it a requirement to maintain status after the I-485 is filed? So after the I-485 is filed, if you were an F1 student and then you filed an I-485, you could stop going to school, okay, as of the date of the I-485 receipt. However, that does not mean you can go and start working at McDonald's. So working with that authorization, it is a failure to maintain status. But the question really could be rephrased as, must I maintain my underlying status after filing the I-485? And the answer to that is no. But after filing the I-485, you must still not do anything that would be unlawful, if that makes sense. And how about before, just after I-140 approved? Same answer pretty much. After the I-485 is approved, you must work for the sponsor that filed your application, unless you fall into one of the exceptions So it is important what happens after your green card is approved as well.